Today, what are we going to talk about? We are going to talk about feminist jurisprudence in India. It's going to be a conversation like I just told you. Now, Swami Vivekananda had famously said, just as a bird could not fly with one wing only, a nation would not march forward if the women are left behind. It was such a simple concept and it was so clearly understood by almost everybody, not just the intellectuals, but everybody. And yet, here we are where we have to discuss it, where we have to talk about it, where we have to explain why we need equality. So, what is our agenda for the day? Today, we are going to talk about what feminist jurisprudence means, how it evolved in our country, and what is the way forward. Again, I'm repeating, it is not exhaustive. It is not the only important topic or list of topics that you need to be aware of. But yes, this will give you an idea about what we are dealing with and maybe give you thought starters and prompts to delve deep and develop an opinion or a mind of your own to understand it better. So, what is feminist jurisprudence? Feminism, the nasty meaning that it has acquired in the modern day and age because of a lot of factors, we can't even get into what exactly led feminists to be viewed as the demons or the the home breakers. But to understand it simply, what feminism actually means is equality, gender equality. A man with a woman, people who don't identify themselves as men or women, who do not abide by binary gender identities or non-binary gender identities, whatever they want to be known as or whatever they want to be identified as, just to be able to be treated equally and as human beings with rights that should be granted to all human beings. That's the basic idea of feminism. So, feminism is a range of committed inquiry and activity dedicated first to describing women's subordination, exploring its nature and extent, second to asking both how, through what mechanisms, and why, for what complex and interwoven reasons do women continue to occupy that position, and third to change the subordinated position of women. This was the definition of feminism that was given by a famous feminist, Claire Dalton. But to break it down, to simplify it for you, first you understand why the power dynamics between men and women are the way they are. Why do why have men historically considered women to be their property or something that they could exert control over? How has that been propagated? How has that been encouraged through generations in a way that women acquired the identity of being the second sex, as was famously coined by Simone the Beauvoir, who is also another famous feminist that you can study about, look into. So, what exactly led to those power dynamics? How women came to be subjugated? What led for women to continue being subjugated? And what can we do to try to change that? That is the entire study of feminism. Now, we are not going to delve deep into the kinds of feminists and the schools of feminists, and we all know. I hope there are some law students here who've already studied jurisprudence and slept through the lectures. So we are not going to go into the theories and the depths of what each thinker thought or said. We are just going to understand what overall it can mean. And of course, the misconstrued notion of feminism in today's day and age is that women are trying to establish dominance over men. Women are trying to establish their superiority. They want to take revenge. They want to break homes. They want to break the family structure and go out and be notorious, be rebellious, be breaking all the social barriers. So that is a completely misunderstood interpretation of what feminism actually is. I'll tell you an interesting anecdote about what people told me about being a feminist later. But right now we'll just go on. Just remind me, okay, towards the end to tell you about it. Now let's come to what feminist jurisprudence means. Now that we have understood what feminism can be a little bit about, jurisprudence is essentially the study of law. So, feminist jurisprudence focuses on the role of law in perpetuating patriarchy and propounds reforms for demolishing male hegemony. So, it is the evolution of laws in favor of women to make sure that they are at par with men. Now, its evolution in India. In India, feminist jurisprudence has broadly been divided into three phases. Now, before we discuss this, of course, I'm not going to go into the depths because these are just things that you need to study about to know more about, and we cannot have an in-depth discussion about these topics right now. But please, whenever you're studying them, whenever you're trying to understand them, just take an interdisciplinary approach, which means that you cannot understand feminism and feminist jurisprudence in isolation. You have to know that there is history, there is psychology, there is sociology, there is politics, there is law, and they all come into play with each other to actually enact a legislation, to give reasons for lack of implementation, to also give reasons for what and how the laws are being misused, or what and how some laws are not being enacted in favor of one particular section or against the other section. So you have to understand what is happening around the world. You have to understand what is the political culture, what political nature of that particular time. You have to understand what has been the history, and you have to understand psychology also. Now, when we talk about women's role, their social status in the country and in the world, you also have to understand that there's an unconscious bias. There are different psychological explanations to why women are seen a particular way, or one particular class or section or kind of people are viewed as something, and the other class is viewed as something else, or there's skewed power dynamics or subjugation or domination. So there are psychological studies behind that as well, and there are things called unconscious bias. There are things called the need for men to dominate and where it stems from, and how the social structure that we are born in, that we are grown in, how they come into play to help us identify our gender. So as we know, there is a difference between sex and gender. Sex is what you're born with. Gender is what you identify with. And the society, the circumstances that you're in plays a major role in making you fit into a particular box, into a particular category of what your gender role should be. So all of those things also come into play. Now, the first phase is till 1915. What was the first phase of feminist jurisprudence? Until 1915, the basic understanding of feminism and feminist jurisprudence was because of the entry of the British in the country, and also the impact of westernization and things like that. And there was a grown awareness of what is right and wrong, moral, immoral, and things like that. And in that, practices such as sati, remarriage of widows, child marriage, illiteracy, etc., all of these were seen as backward, as regressive. So till 1915, it was about abolishing these practices. Then till 1947, of course, there was Gandhi that actually introduced women to movements against the British to get independence. So at this point, women were not just fighting for equality and equal treatment, but they were also fighting against imperialism, against colonialism. They were also fighting for independence for their country. So there was All India Women Conference and the National Federation of Indian Women that came up in the second phase. Now, these organizations aimed at issues relating to women's political rights, leadership, and roles in parties, etc. So this was actually the period where women were also being brought to the forefront to fight for their nation, to fight for their people, and they were being recognized as an important strata of the population to unite with the rest of the population and overthrow the British rule. Now, what happened after 1947 and what's continuing to happen till today is that there was finally questioning of the social status of women. There was talk about equality, there was talk about employment, there was talk about education for women and other issues that are faced by women, and what is the social status that they have acquired, and why some things are not exactly just or fair. Pranjal, I would request you to tell me that you are still here before I move forward. Wow, thank you. Oh, wow. That's great. I do not want this to be boring and I don't want it to be a monologue, so feel free to interrupt me in the middle. All right. All right. Thank you so much, Pranjal. Thank you. So, this was the evolution. These were the three broad phases of feminist jurisprudence to be introduced in India. Now, before 1923, women were not allowed to practice law. And you will be surprised to know that there were actually these famous two cases which were fought by Regina Guha and Sudhanshu Bala Hazra. You can read up more about them, and they were the first two women to actually have to go to the court and fight and argue about the women being treated as persons under the Legal Practitioners Act, because the Legal Practitioners Act till then excluded women. They considered and accepted only men as people, as persons who could be admitted to the bar, who could be called vakil, who could be called pleaders, who could actually come to the court of law and fight for other people's rights or to represent other people. And women were barred only because they were women. So Regina Guha and Sudhanshu Bala Hazra actually led these movements. They went to the court and they argued that if there is their major arguments were that if they haven't used his or him and they've only used persons, which is a gender neutral term, then you can always go to General Clauses Act to understand what persons mean, and in that if you see, you can imply easily that women are also persons and hence women should be allowed to practice law. But of course at that point, because of a lot of reasons which were political, which were also of course psychological, which were sociological, it hadn't been heard of, it wasn't accepted, and it was supposed to be this small all men group, all men gang at the bar, which actually did not want women to come into their group of any kind, which is also a problem that we face today, although not on paper but in practical scheme of things, that there are these all boys clubs in bar associations of different courts where women just cannot pierce through no matter what. So that happened. They were not in the mood of granting the personhood to women at that point. But then what happened was that there were movements in Canada, there were movements in London, there were movements in other parts of the world where similar things were happening, and slowly there was a ripple effect when London actually granted Cornelia Sorabji permission to be admitted to the bar in 1922, and that's when she also got permission to be admitted to the bar. Hmm. Ah, absolutely. Absolutely, absolutely. So you can read more about Cornelia Sorabji also. She was actually a mixed breed of Indians as well as British, and although she was here, she had a complicated history. So you can read more about that. And she also fought hard to be admitted to the bar, and she got admitted in London, and then she came to India to get admitted in Allahabad also, and which was eventually allowed in 1922, which led to eventually the enactment of Legal Practitioners Women Act 1923. One interesting argument that both Hazra and Cornelia had taken while saying that they should be admitted to the bar was also that there were a lot of cases for Parda Nashi women. Parda Nashi women did come into a lot of property, and they were being cheated, and they required adequate representation. And since Pardanashi women could not really go to the opposite sex or talk to the opposite sex, they could not be represented by the opposite sex, and that was also one of the reasons why women should be allowed to represent other women, other people. And those were the basic arguments that eventually led to this landmark enactment of legislation, Legal Practitioners Women Act 1923, which allowed women to actually become lawyers in the country. Now, again, I'm going to be giving you an overview of Constitution. We're not going to be discussing these articles because this could take not just the day, but the entire week and maybe even the month to actually even comprehensively cover everything that these articles entail. So what we're going to do is we're just going to basically understand how these articles are in favor of women and equality of women. So Article 14, of course, talks about right to equality. Equality of equals. Okay, you have to take that into consideration when you're studying the Constitution. I don't know how many of you are law students and how many of you are just, not law students. But whoever you are, wherever you're coming from, you should know what the Constitution of your country says. So read Article 14 very carefully. It's about equality amongst equals, which also identifies the principle of difference that says that unequals cannot be treated as equals, and there can be intelligible differentia on the basis of reasonable classification. Now, that means that if special laws have to be made for certain sections of the society just because you have to bring them at par with the others, then that is allowed. And if there is a reasonable ground for a particular kind of differentiation, then that differentiation can also be allowed, and equality can only be amongst equals. Now, the factual matrix of different cases keep changing, and it actually depends from case to case, and I am not going to discuss landmark judgments with you because frankly speaking, those are also something that you can read up on your own, and those are something that are actually also very boring, so I'm not going to bore you with all of that. But just for you to basically understand, Article 14 talks about equality amongst equals. Then Article 15 Clause 3 talks about special legislation being there for women and children. Article 16 talks about equality when it comes to public employment. And Article 39, of course, again talks about equal pay for equal work and just working conditions for all people in the country. Now, these articles comprehensively deal with equality. They also deal with non-discrimination. So, Article 15 categorically says that there cannot be discrimination on the basis of sex, on the basis of religion, caste, race, place of residence, or place of the person that you're talking about. There cannot be any discrimination on the basis of these things. And yet principle of difference is also recognized. It is recognized that there is a certain section of the society that would need extra care, that would need hand holding just to bring them at par with other people from the society, to make sure that there is fair competition, to make sure that there is justice. Now, this has been criticized a lot when it comes to legislations that have been enacted, especially for women, by saying that these legislations have been abused and misused and used by women to terrorize men, especially when you talk about Section 498A of the IPC, or when you talk about Domestic Violence Act, when you talk about Dowry Prohibition Act, and things like that, which we will be discussing in the further slides. Now, to that, I would just like to say that the Constitution categorically talks about the historical injustice that has happened, and that these laws and these legislations and this protection is needed to right the wrong. Now, if something has been happening a certain way for the longest time, for centuries, at end, without any relief, without any sort of semblance of justice, then what can you do to right the wrong? The only thing you can do is to make sure that those people get enough opportunities, those people who have been discriminated against, people who have been wronged, people who have been treated unfairly, they get enough opportunities to get back on their feet and to just fight the fight with equality, with justice, at par with other people. So that is why these laws have been enacted. And yes, they are being misused. Pranjal, is that you? Hi. Hanji. Mm-hmm. I understand it's controversial and we can have a discussion, but I would just like, yeah, yeah, yeah. Thank you so much, Pranjal. I'm just sharing my opinions. No, I am not here to offend anybody or to make anybody feel like, what is she talking about? I'm just sharing my opinions and I would love to hear yours towards the end. Yeah. Thank you so much. I am not here to actually offend anybody. This is just what I've seen and what I've experienced and what I think. So please take it with an open mind and with a pinch of salt if possible. Okay, so before we go on to the further slides, another thing. So Catherine McKinnon, another feminist, she propounded dominance feminist theory. She said that sex discrimination in the eyes of law is based on either sameness or difference in men. It shouldn't be like that. Why are we just giving men that status that we have to reach where the men are, which again implies that the men are above women, and the fact that women and men are actually different, with different needs, with different psychological upbringing, with different circumstances, with different bodily structures. So there is that difference, and you have to recognize it, acknowledge it, treat it as such, instead of saying that they should be completely equal to where men are. So this was also an interesting theory that you can read more about. It was a dominance feminist theory, and that actually talks about not just comparing yourself with men and saying that we want to be where men are. We actually just want to be recognized and acknowledged for who we are, and to have the rights that we must have as human beings. So, another interesting fact. Now, did you know that only 15 members in the Constituent Assembly were women? And 71 years after the promulgation of the Constitution, we only have 78 women out of 543 members in the Lok Sabha. This is also the highest that India has seen since independence. And yes, there's a reservation bill that says 1/3 of the members should be reserved for women in Lok Sabha, and that reservation bill has also been pending for the last 2 decades. Another interesting quotation that I really liked about Simone, which was by Simone, the feminist that I was talking about, who wrote the book The Second Sex, which is very interesting. So you can read it if you like. So she said her wings are cut and then she is blamed for not knowing how to fly. So if you will not give her the opportunity, the platform to actually not see all the impediments that actually are in her life because of the way the society is, because of the way we are taught, the way we are raised, that we have to take care of our families, we have to give birth to our children, we have to make sure that they are our priority, we can't be selfish, we can't be career driven, we can't be ambitious, we have to choose either our career or our families. There are a lot of things that actually set women centuries behind men sometimes. Again, I'm saying this because this is not just about us having this conversation here today. This is also about women who don't get an opportunity to ever be educated, to ever even have a voice. And there are places like that. Sometimes when you travel from one district to another, you feel like you've traveled back in time, and that one city will be very progressive, very modern, talking about women taking the lead, being on the board, being the director of biggest companies and things like that. And at the same time, there'll be districts in that very city where women will still be in their ghungat, and women will still be taking care of the kitchen and the family and everything else, and not allowed to even talk. Forget about raising her voice or voicing whatever is bothering her. And a lot of the times there are other women who propagate this difference, who propagate this discrimination. There are mothers that teach their children these things, and which are carried forward from one generation to another. There are mothers who differentiate between their sons and daughters. There are mother-in-laws who actually do commit violence or encourage their sons to commit violence on women, on their wives, to get them to do things their way. So there are a lot of nuances to that. I cannot be oversimplifying this, but just to give you a brief idea. Now, women's suffrage, so right to vote. Women gained enfranchisement in the central provinces in 1927 and in Bihar and Orissa province in 1929. At the end of the 1920s, franchisee had been extended to almost all provinces in India. However, because of the property disqualification, less than 1% of the women in the country were able to vote. So although they did have a right to vote, they also had this condition at that point that you could vote only if you have a property in your name, and women were not allowed to own properties at that point, so they could not effectively vote. Now, after Indian independence from Britain, the Indian Constitution in 1950 officially granted women and men suffrage. In 1950, universal suffrage granted women voting rights to all women. This is enshrined in Article 326 in the Indian Constitution, which was a very big deal when countries like USA, UK were also fighting for women to get the right to vote. So now we're going to just take an overview of some of the laws. Again, this is not an exhaustive list. It does not cover all the laws. These are just some laws that I found little interesting to be discussed today. So, there are laws to the rescue, and there's this mentality that women again need to be protected. They need to be taken care of. So it's not exactly rights based, the legislations that have been there, and we're going to go by the timeline. So we're going to see what happened after independence and then after, and so on and so forth, in a chronological manner, just to get a better idea. But these were all again to protect women somehow, and not essentially to recognize their rights as such, until much later when there was some amendments to also recognize women's rights. So the provisions of Hindu Marriage Act 1955, they treat the Hindu joint family traditionally led by a patriarch, which is the Karta, and lineage traced through exclusive male relations at central to all the matters of inheritance. So there's Hindu Succession Act of 1956, in which section 8 deals with how a property of a man dying intestate will be devolved. Intestate means without a will. If a man dies without a will, then how his property is to be devolved upon his heirs, and they talk about it going to his sons and then daughters and then widows, and if then mother, then father, and so on and so forth. That's class 1 heir. If class 1 heir is not there, then class 2 heirs will go, and those are defined in the schedule of the act. And when we compare it with how a woman's property gets devolved, which is in section 15, you'll be surprised to see that the woman's property will first go to, of course, her children. If not children, then husband, and then to the heirs of the husband. And if the heirs of the husband are not there, then only the property will go to the woman's parents. So that is also quite interesting, and this is a law that still exists. Then section 18 of Hindu Succession Act recognizes the right to property of an illegitimate child of sorts. Somebody who has the same father but different mothers will still have some share in the property of the father, but it completely excludes and disregards women who children of women who have the same mothers and different fathers. So uterine blood children is how they call them. They are completely excluded from ever having any right to the property of their mother or their father, according to this act. And then we have Hindu Minority and Guardianship Act 1956 again. So section 6 of this act, it considers father to be the natural guardian of the child if the child is legitimate. Interestingly, if the child is illegitimate, then the mother is considered to be the natural guardian. Then we go on to Suppression of Immoral Traffic in Women and Children Act 1956, which again it talks about it actually looks down on sex workers. It looks down on prostitution, and it talks about, it comes from the idea that women should behave a particular way. Women should do a particular kind of work. Women should carry themselves and conduct themselves in a particular kind of way. So again, it was completely incomprehensible that a woman, out of her own choice, out of her own volition, would like to engage in sex work, in prostitution. And even today, the Anti-Trafficking Bill 2021 that has been floated in the parliament recently and is awaiting assent, even that bill does not recognize the right of a woman to actually choose to be a prostitute. It conflates prostitution to trafficking. To actually, sex work is considered to be completely against the wishes and the consent of women, and it's an overwhelming belief of the system in entirety that a woman cannot possibly consent to this. So the consent of the woman is completely irrelevant, and it is already assumed by the law that this is trafficking. This is against their wishes, and this should be banned. And then, yes, Order 5, Rule 15 of CPC. So if you go through that order, you will see it's about service of summons. Now, summons are basically court notices that go to the party against whom a case has been filed in the court. So the summons tell them that this case has been filed and you have to appear on so and so date to give your defense. Now, Order 5, Rule 15 talks about the summons being served upon an adult person. So if the adult person is not present at home, then the summons will deem to be served if it is received or if they are received by any other adult member in the family. Now, before 1976, it categorically said that it could only be considered to be served if it is being collected or received by an adult male member, and adult females were completely disregarded. So you were basically, and there was also this proviso that said that servants will not be considered to be members of the family. So you were essentially by implication as a woman at par with the servant, and if you are at home and you have to receive summons on behalf of another adult male member of your family, then it will not be deemed to be served if you receive them before 1976. Then we have, of course, a Dowry Prohibition Act 1961 that was enacted to make sure that these things, that women getting married to a man, then there was this custom, there is this tradition which actually continues to exist and continues to plague, and this act has not been very successful. That says that if a man is marrying a woman, then he's doing her a favor, and that is why there's kanyadan, and there's this all of this tradition of giving dowry, which is given by the bride's family to the groom and the groom's family, and the more the dowry, the better the chances of your daughter to be happy in her sasural. So that was basically the custom, which is also interesting in a way that if you go back into the history of the country, you will realize and see that there was a custom before that where the groom's family and the groom were actually supposed to give some consideration or some gifts to the bride's family for the bride's father to be giving away his daughter. And that somehow just became about it just got reversed. And then there was a lot of harassment, there was a lot of cruelty, there was a lot of torture that was being faced by women for not giving enough dowry, for not being able to afford a certain thing that the groom or the groom's family wanted, and which led to the enactment of Dowry Prohibition Act, which not just penalizes taking dowry, it also penalizes giving dowry. A list has to be maintained of the items that have been exchanged during the wedding, and although it's quite comprehensive, but the implementation is where it has lagged. And yes, there has been a lot of misuse of this act also, which has taken away the faith of the judiciary in cases which are also more authentic and more real, but they do not get the same hearing that other cases would, because of how often this law has also been misused by women. And yes, there is another connected law to Dowry Prohibition Act is Section 498 of IPC, 498A, which was inserted in 1983, which for the first time criminalized cruelty that a woman is subjected to by her husband and also by her husband's relatives, which includes mother-in-law, father-in-law, sister-in-law, brother-in-law, anybody else who have committed the acts of cruelty. The definition of cruelty is not given anywhere, and it is being interpreted by judiciary on the case-by-case basis. This provision again has also been misused a lot of times, which has also led for the judiciary to lose faith in women who actually went through something and actually appealed or prayed for the judge to listen to her case under Section 498A. So there's a lot of suspicion that surrounds it. And then Section 304B of IPC was also inserted in 1986, which talks about dowry deaths. So there are certain ingredients that must be present if a woman's death has happened in a suspicious manner in her matrimonial home within 7 years of her marriage, and then it can be a dowry related death, which can lead to an investigation against the woman's husband and the woman's husband's relatives under this particular section. Now, one thing again I would like to say that although these laws have been misused, but I think personally, in my opinion, that there are a lot of laws that have been misused in our country, and sedition is one of the biggest examples of how blatantly laws can be misused. And yet these are the particular laws that have gained a lot of traction, a lot of traffic, a lot of arguments when it comes to women subjecting men to unfair treatment or cruelty or terrorizing them with these legal provisions. So yeah, then we go on to the Maternity Benefit Act 1961, which has been amended in 2017. So it actually gives paid leaves to women, finally recognizes that, okay, women giving birth is a natural phenomena and it is not an impediment to the growth of the company. Their paid leaves were increased from 12 weeks to 26 weeks. And now there's also a code on Social Security 2020, which has not been notified yet, which seeks to make these provisions a little more gender neutral, and which seeks to codify and make sure that it is not just for formal sector, but also people working in the informal sector are taken into consideration. So it is a good legislation, but it is yet to be enacted, and it is yet to be implemented. So we'll see. Yes. Yeah. Yes. 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 I I completely agree. I believe there was a recent decision also. I am not too sure if it was from India or somewhere else, where paternity leaves are actually being given in corporates. But yes, Indian companies and Indian jurisprudence has a lot to catch up to. And I completely agree that maternity leaves should be corresponded with paternity leaves as well, if we are trying to establish equality in the true sense of term, in the real sense of term, because the responsibilities have to be equally divided. And again, if we just focus on maternity leaves and not paternity leaves, then we are reinforcing the gender roles that have been established by the society, that say that only women are responsible to take care of their children. So you're absolutely right, Pranjal. um, Now we go on to Medical Termination of Pregnancy Act 1971. The latest amendment happened in 2021, and it is an important legislation. It was just recently notified also. So women are allowed to actually terminate their pregnancy. If earlier the gestation period should have been, the upper limit of the gestation period was 12 weeks. Now it is 20 weeks. And from 20 to 24 weeks it has gone in certain circumstances which have been mentioned in the act. The good thing about the amendment is that it now includes unmarried women. Before that, it was just talking about married women being allowed to medically terminate their pregnancy. And it also includes unwanted pregnancy. So unwanted pregnancy is a ground for abortion, which has been recognized in the amendment, which is again a welcome move. Now this is an exception. Yeah. Yes. 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 Absolutely. Yes. Yes, absolutely. We are a little more progressive than even the Western countries in these circumstances, in these situations. So you're absolutely right. Now this forms as an exception to section 312 of IPC, which actually penalizes, it criminalizes voluntarily causing women to miscarry. So that this act forms an exception to that, and it says again that women can medically terminate their pregnancy. Now again, while the legislation is great and the amendments are more than welcome, but there are still some things that, the underlying factors that we can look at and study more about, is that again consent of the woman is not given paramount importance, because even in the amended act you can get it medically terminated if you have the consent of a registered medical professional. If you are 20 to 24 weeks pregnant, then you will need the consent of 2 registered medical professionals. So it's not just about your consent alone. And this comes after the Puttaswamy judgment also, which recognized the woman's right to her body to be equivalent to right to privacy, which can fall under Article 21 of the Constitution. So this is again food for thought, just something that we can talk about, we can think about. Now some more laws we'll discuss in this slide. So there is Equal Remuneration Act of 1976, which talks about equal pay for equal work. And then there is Code on Wages 2019, which seeks to codify and subsume these laws on employee provident funds and equal pay for equal work again, and Factories Act, and so on and so forth. Now, this does talk about women getting an equal pay for equal work, but the definition of equal work is so narrow that it hasn't been adequately interpreted in order to favor women who are actually working on the field, and if they actually are demanding equal pay. And personally, I've been a part of organizations and companies that have explicitly told me that they don't believe in equal pay for equal work, and they cannot be bound by anybody because they are not under the government, or they are not, they're not that big an organization that they have to face penalties for not following this particular act. So there are people like that also out there. And this also lags behind because again it does not identify the difference of circumstances of men and women, and there are a lot of companies and organizations that look at hiring women to be an impediment, because you have to give them maternity leave, you have to make sure that they're safe, it becomes the employer's responsibility to ensure that women are not kept in office till late, and if they are kept till late then it becomes their responsibility to safely drop them back home. So that also becomes a problem. Then they say that women get married and they leave the country, or they go from one place to another, so it gets very hard and you've spent all this time on training them and everything, which goes to waste. There are people, and this is something that I'm telling you from personal experiences, that I've had these discussions, I've met people who actually have said this to me and who believe this wholeheartedly, and that's why they resist and they restrain themselves from actually hiring women. So yeah, and all of these things don't really have any bearing on the legal profession, because the Bar Association, when you think about it, does not really provide much of a relief to women, or there are still there are district courts where there are not even functioning toilets for women, so forget about this. And then again you also have this liability of the employer, that they have to have a crèche nearby to make sure that women don't have to choose between their work and their families, and there's a work-life balance also, and there's them being able to take care of their children also. So that is also something that a lot of companies don't want to comply with, so they avoid hiring women altogether. Code on Wages again talks about not just women but tries to bring all genders under the umbrella, and they also try to codify it to include formal and informal sectors. Again, the legislation has not been implemented yet. Then we talk about Domestic Violence Act. Now this is a very, very good legislation. I believe you've already had a lecture that talked in detail about domestic violence. I don't know if you in particular had attended that lecture or not, or what all was covered or not. But just to give you a brief idea, that Domestic Violence Act for the first time recognizes not just the physical abuse as amounting to cruelty, but it also recognizes the emotional abuse, the psychological implications, the economic abuse that takes place when these situations happen, or when women are abused in their own homes. And there's a famous slogan which became very famous in the second wave of feminism, that personal is political. So a lot of the times, a lot of the things that are happening to women, the laws and the government and the people, they take a huge step back and they say that this is their personal matter, we can't interfere in this. And that is how the abuse on women had been propagated, had been encouraged, had been silently assented to for the longest time, because everybody just said, okay, that's their private matter. And Protection of Women from Domestic Violence Act for the first time made their private matter a public issue that had to be dealt with. And they gave effective reliefs which could be granted in the civil law, which were residence orders, protection orders, monetary release, compensation, custody orders, all of these orders that the women can be given while the case is still pending. And if there was a breach, then there was punishment for the man also. The husband or the husband's family members. Another interesting thing about this act is that it recognizes the abuse that happens not just to wives, but also live-in partners, also mothers, also sisters, anybody else who's living in the domestic setting with an abuser. That person, that woman, has a right to proceed against the abuser under this act, which is also very, very it's a very noble initiative. Again, of course, I believe there will be people here also, and we will have this discussion later, that this also has become another act, another legislation that has been known to be misused by women a lot. Then we go to Hindu Succession Amendment Act 2005, which gave daughters the right to become co-partners of their father's property as the sons or the brothers could be. So it put them on the equal footing. This was another legislation that was welcomed and that was considered to be a victory for women. Then we have Sexual Harassment of Women at Workplace, the POSH Act. Again, this is very important because yes, again, it talks about just protection of women at workplace, and there have been talks and there have been initiatives to make it gender neutral, to make sure that there is no discrimination at workplace. But at the same time, this is also a very welcomed legislation, piece of legislation for women who had been exploited. First, you don't let them study, you don't let them get higher education, you don't let them get out of the home to actually make something of themselves. Then when they do, then they have to fight for equality even at workplace. You have to work as double as hard as a man to reach half of where the man is sometimes in the professional world, and it gets very difficult. And then again, the power dynamics are such that it is so easy to exploit a woman at workplace. It is so easy to take advantage of her, to discriminate against her, or to harass her. And the act actually takes care of that. Although there are a lot of shortcomings of the act as well. It talks about creating an internal complaints committee, which again is formed of people who are working in that company, which makes the functioning of the ICC not as objective, not as independent as we would hope. So if there's a complaint against the employer, you have to look for other means. And yeah, there is a local complaints committee as well, but the implementation of this act lacks a lot of it lacks a lot of traction. It does not it has not been complied with. It has not really bore the fruits that were hoped at the time of enactment of this act. Then Criminal Law Amendment Act 2013. This was after the unfortunate case, the Nirbhaya case. And a lot of changes were brought to the criminal legislations when it came to IPC, when it came to Indian Evidence Act, when it also came to Criminal Procedure Code. So this actually made it even more strict for rape laws. For anybody who commits rape, there was death penalty that was introduced. When it came to rape victims, the medical examination, how it has to be done, the questions that can be asked by the defense counsel, and all the things that have to be taken care of, that can make the life of the victim a little easier. Those amendments were made. Then there was introduction of voyeurism, introduction of stalking and other ways of sexual harassment in the IPC 354A, B, C, D. They were introduced. What did not happen even in this amendment, even though Justice Verma Committee, which was responsible for suggesting these amendments and for researching, they had suggested that you criminalize marital rape. Despite the suggestions, it did not happen. And marital rape continued to become an exception of Section 376, which said that if it will be rape only if the girl is below the age of 15 years old. Otherwise, if they are married, then it is not considered to be rape. Now, there's a lot of arguments and there's a lot of talk around this also, that this is one particular area where India is lagging behind badly, despite the fact that countries like UK and Canada and US and other developed nations, even Nepal for that matter, they have criminalized marital rape. Why India cannot do that? So Independent Thought versus Union of India, this was an interesting judgment in 2017. The court incriminated non-consensual sexual contact with girls below 18 years. So in section 376, exception 2, where it was written that if the girl is under 15 years old, then it will be considered to be rape. That was increased to 18 years. But no amendment has happened in the law yet. This was the judgment that had come. It was a landmark judgment, but the law has not been amended yet. In India, it's very strange. If a woman who is under 16 years old of age, if she has consensual sex, then it is termed as rape. And just because a woman is married and even though her husband forcefully has sex with her, then it is not rape. Moving on, section 149, clause 1, read with clause 49 of the SEBI listing agreement and rule 3 of the company's appointment and qualification of directors rules 2014. So we are talking about Companies Act 2013, section 149 of that act. It provides that every listed company or public company with paid up share capital of 100 crore rupees or turnover of 300 crore rupees or more shall appoint at least one woman director. Now, while this has been again considered to be a welcome move, but it was noticed in a lot of surveys in 2014 that a lot of companies hired women and appointed them as directors only to fulfill this rule, fulfill this compliance, this liability, to make sure that the employers are not penalized for not doing this. So instead of actually understanding the intent behind this enactment, intent behind this amendment, there were ways to just skirt around this and to just show that okay, this requirement has been fulfilled just for the heck of it. Now there was this interesting study that was done by Harvard Business Review in 2017, which talked, they did this survey on Supreme Court judges in the US for the last 15 years, and they saw how women judges were 3 times interrupted more than a man judge would be interrupted. And they saw this behavioral change in women, not just in Supreme Court but also in the corporate world, in business world, that they started becoming less polite. So and this is also something that I can tell you from personal experience, that there are certain courts and there are certain judges where they would not take you seriously until and unless you're shouting, until and unless you are being completely, unleashed, because your opponent, your male opponent, your male counterpart will be doing that. So you are also expected to do that. At the same time, there are judges who consider that to be brash and abrasive and aggressive and completely unlike women. So, you can't really be sure of what to do, what not to do. But according to the survey, it has been seen that women who want to reach a certain place in their career, they are, changing the way they talk, they are changing the way they behave, becoming less polite, more aggressive to be taken seriously. And this is actually a psychological study. Yeah, absolutely. 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 Another sad fact is that India ranks 140 out of 156 countries in the Global Gender Gap Index, which is the latest in 2021. Now, these were some of the laws that I wanted to discuss with you. I know we've already exceeded the time limit within which we were supposed to complete this session. But just before we open the floor for questions and to have a discussion, I would just like to suggest some pointers for our way forward. What I think the problem is with the framing of the law is that it focuses on sexual wrongs and not sexual rights. It is victim oriented and not rights oriented. So you would consider women to be victim, women to be, needing protection and needing that umbrella of sort, but you will not be considering them to be having rights, or to be doing something, or to be wanting something, or to be in a particular place at a particular time. An effective law can only be enacted when it is drafted by people who acknowledge that women are individuals who have the right to assert their will, to live in a society with dignity, and to work without being demeaned due to their gender. The focus instead needs to be laid on wiping out the preconceptions of how women should behave ideally and try to put an end to the stereotyping of women. We don't need laws, we have a lot of them. We need minds. We need open minds, accepting minds that are free from bias and look at women as equals, not better or worse than men. So we need a gender responsive approach. Yes, gender neutral as well, but gender responsive in the sense that you understand that they are built differently and they have different needs, but that does not make one superior or another inferior. They are all equals, they're all humans. And this does not just talk, I'm not just saying this about men and women. I'm also talking about transgenders. I'm also talking about queer community, LGBTQIA plus community, everybody who wants to identify themselves as a particular binary or non-binary gender identity. They have a right to do that. There has to be representation, there has to be participation of the people for whom you are making those laws. If you don't ask them what they need, for example, when we talked about prostitution and the anti-trafficking bill, all of those laws and all of those enactments, the CETA enactment, also the suppression of immoral trafficking, they were all drafted, they were all enacted without hearing from the side of people who were engaging in sex work, who were prostitutes, who were doing what everybody else deemed to be immoral. So nobody consulted them, and yeah, absolutely, exactly, absolutely, absolutely, absolutely. I completely agree. This is such a simple thing. It is so basic, and yet, because of the skewed power dynamics, because of the way it has always been, and patriarchy is the oldest, most powerful system that is common to the entire world. So, when you're fighting that system, that is one fight that is not going to be over soon, and that is one fight that is completely worth fighting every step of the way. That is the only fight that actually matters, I think. And that's why there's a lot of resistance, there's a lot of difficulties that, and a lot of challenges in just being the way we want to be and living a life the way we want to live, because it hasn't been allowed for the longest time. And so yeah, you're absolutely right, and this is the sad truth, but this is also the reason why we have to keep speaking up, we have to keep talking about it. And there has to be grassroots gender sensitization programs. So you have to talk to people at an age when it is for them to also start identifying themselves with certain categories or certain boxes or certain identities. So when you talk to children at an absolutely, yes, absolutely. Absolutely, absolutely right. And there are countries who have invested in gender sensitization programs, and they have seen marked progress. There are countries like Luxembourg and other Scandinavian countries that we can look at if you want to base our model onto some other countries' model that has successfully worked. But it has to be done. There has to be gender sensitization at an early age. It has to be inculcated in our education systems. We have to address social norm issues. If there's something that you cannot change inside of your mind, it will never change outside of it. So I believe personally that there has to be change internally first. You have to change your mindset first. You have to be more accepting. You have to be more understanding of different identities and different approaches there can be, and more accommodating and more adaptive in order to actually bring about a change. Um, now, before, yeah, yes, 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 absolutely. Absolutely. And it's going to be a very challenging road ahead. And this is something that we as women we face on in our lives on a daily basis in one way or another. There's always that discrimination, the subtle discriminations that we come across in our lives, whether it is in a professional life or a personal life. And we have to actually center ourselves and make sure that we are taking care of ourselves, and in a world that is hell bent on making us feel like we are wrong and we should apologize, we are sure of who we are and we are sure of what we want in life, and we keep marching on. So here are just some reminders that I want you all to keep with you, and just go back and look at these to really remember why you're doing this or anything in life in the first place. So there was this another interesting quote that I came across. It was, if you don't like being a doormat, then get off the floor. So certain reminders, just participate, stay focused, make it count, ask questions like Pranjal is doing right now. And like I hope all of you will once I end this presentation. So ask questions, exercise your right to know, talk about it. The more you talk, the more clarifying it will be for you, even if nothing else comes of it. Speak up. If you or anyone around you is wrong, regardless of who they are or where they come from, speak up. If you don't, Nobody will. If you don't change, if you don't be the change you want to see, then nothing will change. Know yourself so you don't get exploited. Hmm. Exactly. Exactly. Absolutely. Absolutely. You have to be the narrator of your own story. You know, the lion will never write for the deer, things like that. But yeah, you're absolutely right. If you are facing something that you think is unjust or unfair, or if you see anybody around you facing that, you have to speak up. Do not just sit quietly and acquiesce, because when you do that, that's when the complacency sits in, and that's when things remain the way they are, and then we keep complaining that why is no change happening. Again, know yourself so nobody else can come and tell you, okay, this is who you are and that is why you should do this and that and blah blah blah, because that's the easiest way, the easiest technique for them to exploit you. So know yourself so nobody else can do that for you and exploit you. Find a balance. Ensuring healthy work life balance does not make you weak, and you have to keep standing your ground no matter what other people tell you and say that, okay, no, you know, you have to have ambition, you have to forget about the hours that you're spending or the late nights that you're doing. The more you do all of this, the further you'll go in your life. No, you have to be responsible, you have to also take care of your mental health, and doing that does not make you weak or less accomplished than anybody else. And the last, inspire one another. We encourage and see the good in everyone. So you have to be somebody who inspires others, and you have to find things in others that inspire you, instead of having those big role models, people who are just, you know, so far away that you don't really even understand how they are as real people. So take inspiration from people that you really know, people who are around you. And if you have any questions, anything else that you would like to discuss, you can get in touch with me on LinkedIn, on Instagram. My channel's name is Law Chakra by Sanya. And you can also email me at lawchakrabysanya@gmail.com. With this, I'm going to end the presentation, and finally we can start talking.